Welcome back to the series. In this video, we're diving into one of the more practical and sometimes overlooked areas of workplace relations, dispute resolution. Because no matter how well a business operates, conflict is pretty much inevitable. People have different needs, expectations, and personalities, and sometimes those differences lead to disagreements. In the world of business, especially when it comes to managing people, being able to resolve disputes effectively and fairly is absolutely critical. It not only protects the rights of the people involved, it also protects the reputation, efficiency, and overall health of the business itself. In this video, we'll look at the ways disputes are handled, starting with informal methods within a business, and moving into more formal approaches like mediation and arbitration. We'll also look at the important role played by the Fair Work Commission, and why good dispute resolution matters. Understanding workplace disputes. A workplace dispute is essentially a disagreement between an employee or group of employees and the employer. Sometimes it can be between employees themselves, but for the most part, in the context of workplace relations, we're talking about disputes that involve pay, working conditions, rosters, contract terms, job security, or disciplinary action. It might begin as a concern raised in a meeting or email, or it might start with something more emotional, like a feeling of being treated unfairly. If the issue isn't addressed early, it can grow into a serious conflict, affecting productivity, morale, and even the culture of the workplace. Most businesses try to avoid formal disputes by putting in place what's known as a grievance procedure, basically a step-by-step internal process that employees can follow if they have a problem. This might begin with an informal conversation with a supervisor or manager. If that doesn't lead to a solution, the issue might be raised with human resources or senior leadership. In many cases, this is where the dispute ends. It gets handled internally and quietly. But when it doesn't, more structured resolution methods might be needed. Mediation, collaborative resolution. One of the most commonly used formal methods is mediation. Mediation is when a neutral third party, known as the mediator, helps the two sides in a dispute communicate more effectively and work toward a mutually acceptable solution. It's important to understand that the mediator doesn't make a decision. Their role is to facilitate the discussion, to encourage respectful communication, and to help both parties find common ground. Mediation is often voluntary, and it works best when both sides are open to compromise and genuinely want to resolve the issue. For example, imagine a group of employees believe they've been treated unfairly in the way shifts have been allocated over the holiday period. They feel certain people are being favored. They raise the issue, and it's not resolved internally. Mediation might then be used, perhaps with someone from outside the business, or even someone from the Fair Work Commission, guiding the conversation and helping everyone involved reach a solution, like adjusting the roster or offering time in lieu for those affected. Mediation is often preferred because it's quicker and less expensive than more formal methods, and because it aims to preserve relationships rather than escalate conflict. It's a collaborative process rather than a combative one. Arbitration, binding resolution. But sometimes, no matter how much discussion takes place, the two sides can't agree. That's when arbitration may be used. Arbitration is a much more formal process, and unlike mediation, it results in a binding decision. In arbitration, both sides present their arguments, often in a structured setting, and an independent third party, usually from the Fair Work Commission, makes a final decision. This decision is legally enforceable, meaning both parties must accept and follow it, even if they don't fully agree with the outcome. Arbitration is a bit like going to court. There may be formal submissions, witness statements, or expert testimony, and the focus is on applying the law and industrial relations principles to the facts of the dispute. Let's say an employer and a union have tried multiple rounds of negotiation over a new enterprise agreement, but after months, they are stuck. Neither side is budging, and industrial action is on the table. Rather than letting the situation spiral into strikes or lockouts, the matter could be referred to arbitration. The Fair Work Commission would hear both sides, consider all the evidence, and then make a ruling that both parties must follow. While it may not leave everyone happy, arbitration brings finality, and that can be crucial for getting the business back on track. The role of the Fair Work Commission. The Fair Work Commission is Australia's independent workplace relations tribunal. It plays a central role in dispute resolution by offering services like mediation, conciliation, and arbitration. It also has the authority to approve or reject industrial action and to intervene in disputes where legal requirements haven't been followed. Think of the Fair Work Commission as the umpire of the industrial relations system. When employers and employees can't resolve things on their own, this is the body that steps in to ensure the process is fair, lawful, and in line with national standards. It doesn't automatically take sides. Its job is to apply the rules and guide parties toward resolution, ideally before things get out of hand. Why dispute resolution matters. So why does all of this matter? Why does it make a difference whether a business resolves a dispute through mediation or arbitration, or whether the Fair Work Commission steps in? The short answer is, workplace disputes can seriously disrupt a business if they are not handled properly. They can lead to legal costs, lost productivity, poor morale, and reputational damage. Customers notice when staff are unhappy. Team culture can quickly collapse if employees don't feel heard or supported. But on the other hand, businesses that manage disputes well can actually become stronger. They demonstrate a commitment to fairness. They show employees that their voices matter. And they reduce the risk of ongoing conflict by dealing with issues transparently and respectfully. Good dispute resolution isn't about winning, it's about restoring balance and moving forward with clarity and mutual respect. To wrap up, let's bring it all together. When a workplace dispute arises, it should first be addressed internally through the business's grievance procedure. If that doesn't work, formal processes like mediation can be used to help the parties communicate and find common ground, with the help of a neutral facilitator. If that fails, or if the dispute is particularly complex or serious, arbitration may be necessary. In that case, the Fair Work Commission steps in and makes a binding decision. Understanding these processes, and the role of each participant, is key to managing people fairly and effectively in any business. Thanks for joining me in this lesson. You'll find a full set of study notes and practice questions in the description to help you revise what we've covered. In the next and final video of this unit, we'll take a step back to review everything we've learned in Area of Study 2, and I'll share some practical tips for preparing for SACS and the exam. I'll see you there.